Paul Jones, were you destined to be a lawyer?
No,
Why?
just wasn't in my plans.
Talk a little bit about your mom and dad.
My mom and dad. My mother was born on a farm in southern Indiana in 1912. Grew up on the farm. They eventually moved to some small town in southern Indiana. Survived the flood of the Ohio River one of those years. Eventually moved to Chicago when she was 17, had graduated from high school. My father was born in Cottage Grove, Oregon. He was the first in the family to go to college. He did it the hard way. He went to college for a year, worked for a year to earn some money, went to college for a year, graduated during the Depression, and as an electrical engineer ended up getting a job in Chicago in the telephone industry. And that's where he and my mother met, married, had 2 kids in Chicago, moved to Rochester, New York, where I was born.
And you went through did you go through the Rochester school system?
I went to St. James Catholic School in Irondequoit and McQuaid Jesuit High School in Rochester. So I did not go to the public schools.
I graduated from high school when?
1967.
So 67 you graduate. And was it destined that you were going to go right to college?
I would say pretty much, yeah.
What were your choices at the time?
My choices of college? I love telling this story. I applied to one college.
Notre Dame.
Got in.
That's why you were in green.
And my Notre Dame tie. I did have the advantage that the summer before my senior year, we had a family event in Chicago, and on the way out, we stopped at Notre Dame and visited the folks in the admissions office, and the guy looked at my high school record and said, "You're good, you're good." So I didn't apply anyplace else.
So you go to Notre Dame and graduate in 1971.
Yes.
Was law school then the next step?
No. There was a next step.
Okay, and it was?
My undergraduate degree is in physics, and I had enough math and education courses to get myself licensed in the state of Indiana and the state of Illinois as a teacher. And I taught math in a public school on the south side of Chicago for roughly 6 months. I had graduated in December of 1970, a semester early. So I had to get a job. Got a job. Thought I was doing the right thing. It was horrible. It was the worst experience of my life. It was probably worse for the kids. And not too far into that experience, I had taken the LSAT and I had applied to some law schools, and I finally decided, where's that stack of acceptance letters? Because I'm not going to be teaching next year. And one of them was Notre Dame, and I went to Notre Dame.
So you're a double-domer.
Double-domer.
And during that time period, the football team stars were?
I had 7 years of Ara Parseghian as my coach. The way I tell the story is, in the fall of 1967, I arrived on campus. Notre Dame was defending national champions in football. I stayed for 7 years on campus, or at Notre Dame, at which time the team in the fall of '73, my final year of law school, won another championship, and my work was done.
So then?
Joe Theismann was my classmate, undergraduate.
Okay.
I can't say that I ever knew him or probably didn't meet him. At the same time, Notre Dame had a pretty good basketball team. Austin Carr, Sid Catlett, Collis Jones. Digger Phelps was a fairly new coach then. And the 3 guys I just mentioned all had NBA careers. And there, my claim to fame is that Austin Carr was in my theology class. At Notre Dame, in your first year, you had a requirement of 1 semester of theology, 1 semester of philosophy, and Austin Carr was in my theology class. And I remember the professor, probably not really a professor, taking me aside and saying, would you spend some time with Austin to get him through this? Austin didn't have, let's just say Austin didn't have the benefit of going to a Catholic grade school and Catholic high school to learn the real theology. And so I got him through.
God bless you. On behalf of
I don't think he remembers, but, whatever.
you never know.
Never know.
I think he's still among us, Austin, so at some point.
He was at our reunion 5 years ago. I've got another reunion. Maybe he'll be there this another month.
Probably a moment where you can just get your phone in front
Yeah.
of you. Do you remember
Yeah.
our theology class?
Yeah.
And the president at the time was Father...
Hesburgh,
Okay,
Richard Nixon's favorite college president.
yep.
Yep.
Did you interact with him at all?
I met him a couple times, shook his hand. He was visible on campus, I will say that. He didn't, just hide in some tower.
So graduate, 71, 72?
My undergraduate class was 71, my law school class was 74.
74. And then did you launch out? Where did you think you might practice? Or did you think you were going to practice?
Well, I did. It's interesting. I first thought, well, given my undergraduate background, maybe I ought to look at patent law. And in fact, I remember one summer talking to you remember there was a company in Rochester called Eastman Kodak? Talking to their patent people. I ended up not being too interested in that. Then when I took a tax course in law school, I thought, this is good. They got rules, and all you got to do is follow the rules. And for a while I thought that would be cool. And then in my second year of law school, I took a criminal procedure course. I mean, everybody had to. And my professor was Leslie Fascio, who came from Buffalo, came out to Notre Dame from Buffalo with William Lawless. Lawless was a Supreme Court justice locally in Buffalo, and not really sure what the circumstances were, but he got offered the deanship at Notre Dame. He took it and took Fascio out with him. So in the course of things with taking that course, or maybe it was a semester later, I was a hardworking law student, and Fascio said to me, have you ever thought of applying for a clerkship on the Court of Appeals? And I pretended I knew what he was talking about. And I was going, well, yeah, I'd be interested. And so that summer after my second year of law school, I interviewed in Buffalo with Judge Jason, who was on the Court of Appeals. Court of Appeals, I'm sure everyone knows, is the highest court in the state of New York, highest appellate court. And at that time, at least, I think it's still the same way, judges had local chambers wherever they were from, and then from late August or early September through probably June, they would spend 3 weeks in home chambers, 2 weeks in Albany. So the law clerks traveled with the judge, but the law clerks lived wherever the judge lived. So that brought me to Buffalo. By that point, I thought probably I would end up in Rochester. My parents were still there, practicing law. And I had offers from 2 or 3 law firms in Rochester. And then Jason, he was a great person to work for, a great mentor. But it was very interesting. When he interviewed me, he said, now understand that if I offer you the job, you're taking the job. There was no, well, think about it. Yeah, sure, okay. So, in fact, then on the morning of Southern Cal coming to Notre Dame to play football in that national championship year, Jason called me. I was in the law, I don't know, he had the number for the law school, the law review office, and he reached me there and he said, I'm offering you the job and you've already said you're going to accept it. Okay, done deal. So but I had also stayed at school in the summers and had been taking law courses at the law school in the summer. So I was finishing up in December of my third year. Notre Dame, maybe nobody does, but Notre Dame won't let you do that anymore. You've got to be 3 years in residence, but I did then. There were probably half a dozen of us that did the same thing. So I needed something to do between January and August of 1974. And Phillips Lytle was one of the law firms that was interviewing on campus, Dick Birmingham, and they made me an offer. Of course, I had the commitment to Jason, which Phillips Lytle was very good about it, because I ended up coming here and working at Phillips Lytle from January until, the middle of the summer, and then started the 2 years with Jason. I guess they thought well enough of my work at Phillips Lytle that when I was finishing up with Jason, they asked me to come back, and I did, and stayed here ever after.
When did you take the bar exam?
I took the bar exam in February of 1974. And, I know you want this to be a very short tape, but I'll tell you a story.
Sure.
I'll tell you a story.
I got time.
So,
at our age, we have lots of time.
So, at Notre Dame, there was one professor who had taught for years, maybe at Fordham, I don't remember, but one of the New York City law schools. And he taught federal procedure at Notre Dame, but he also taught a New York procedure course, maybe once every couple of years. And frankly, I don't remember if I took it, but that was, apart from that, there was just no opportunity to learn New York law at Notre Dame Law School. And as you know, New York procedure, a lot of states have more or less adopted the federal rules. New York has not. Did not then, not since. So naturally, I took a law review course, a bar exam course.
Mm-hmm.
And I don't know, maybe it was PLI at the time, I don't remember. What I do remember is it was out at the UB campus in the law school. And this was when the Amherst campus was just being built. There were only 3 buildings that were open. The law school was one of them,
Mm-hmm.
Which meant that parking was a breeze. You go over to UB now, parking's a headache. And at that time, I don't know if it's still the same rule. At that time in New York State, if you had taken the bar once and failed it, you could not take it again in June or July when it was offered. You had to take it in February.
Mm-hmm.
So I'm in this bar review course with people who have, probably every one of them has flunked the bar already once.
Yeah.
And one thing that was really nice about it, it was all on tape. It was all on tape.
Mm-hmm.
And you came, you sat in this big auditorium, and you listened for 3 hours. But the evidence tapes were all done by Irving Younger, who was a marvelous teacher, marvelous professor. But I had to learn New York law. And apparently I did, because I passed. But the story I wanted to tell, so all of these people have already failed the bar exam once. And one guy apparently had a deal with, I'm going to say PLI, I think it was PLI, to run the sessions, which meant he took the tape, he put it in the machine, pushed the play button, sat back. I don't even think he took attendance. And he got the course for free. And he was a loudmouth. And he had this posse of people that, always hanging around. So the bar exam then was given in the Statler Hotel in the big mezzanine there. And, so you go an hour and a half, 2 hours, whatever it was. And there's a morning break. And I remember going out in the hallway, and the guy who had been plugging the tapes into the machine was out there talking with his posse and analyzing this one question that had been on the bar exam. And his analysis, I just kind of listened. His analysis was completely different from my analysis. And I said to myself, I've passed the bar exam. And I did, and I don't know if he did or not. But I knew at that first morning recess that I had passed the bar because I was had a completely different answer from somebody who had already failed the bar once.
That's perfect. And so you passed the bar, and then did you work here, when you were here for the 6 months, the interim, integrum, what did they do? Did they have a cycle of things they exposed to? Or we know you now as a litigator, but did they expose you?
Yeah, I'm trying to, I think it was just sort of like a prolonged summer associate arrangement, really. And, you know, it was almost all doing legal research and writing memos and stuff, but it seems to me I worked for pretty much every partner in the place over that period of time. I even had one assignment from Bill Lytle, Phillips Lytle. Lytle was still, well, let's see, it was Phillips, Lytle, Hitchcock, Blaine, and Huber. Lytle was here, Hitchcock was still here, well, Blaine was here, Huber was gone. So, yeah, Lytle, he was a nice enough guy. It's just, you know, he wasn't real friendly, or at least he wasn't real friendly with me. But he would come into the office and he might take off his suit coat, but he never took his vest off.
Oh, really?
He never took his vest off. And so whoever was supervising my work, and I don't remember now who it was, said, Bill Lytle's got a question he wants somebody to look at. Why don't you go talk to Bill Lytle? So I did, and apparently some good friend of Bill Lytle's had been called a prick by somebody. He wanted to know if he might have a lawsuit for slander. I looked it up, and I did some work, and didn't give the answer that Lytle wanted. The answer was, well, tough luck. You're not going to win that case.
So then you go off with Judge Jason for 2 years. Any notable cases? Do you remember any things that sort of...
Well, I sure do.
Yeah.
I sure do. I mean, there were other memorable cases. Well, actually, two I'll mention. So one case was Slater, S-L-A-T-E-R, versus Gallman, G-A-L-L-M-A-N, 38 New York 2nd 1. And the only notable thing about that, it was some administrative law case. I mean, it was as boring as they get. And I don't know how it got to the Court of Appeals. After I was there, the rules changed in terms of how you could get a case to the Court of Appeals. So I don't know if this got to the Court of Appeals as of right or by leave of the court. Anyway, it was in the Court of Appeals. And the attorney for the appellant was a guy who was very well known in New York City as a plaintiff's personal injury lawyer. Had no business handling this administrative law. I think it was administrative law. It might have been a real estate tax. I don't remember. And submitted a brief that was more than 200 pages long.
Oh my gosh.
At the time, New York State did not have a rule about how long your briefs could be. Briefs, right? And then his reply. Yeah. So the respondent files a brief that was maybe 15 pages long, if that, because it was a very simple question. And then he files a reply brief that's not quite as long, but very, very long. And then I think the court, they were pretty pissed about it because, someone's got to read all this stuff. And I think they were planning to just let him know from the bench that that was not acceptable conduct. He doesn't show up for argument. He submits. Jason draws the case, and Jason says, well, we're going to affirm. That's real easy. but we got to write something. We've got to write something about the length of these papers because that's unacceptable. And all I'll say is read Slater against Gelman, 38 New York 2nd 1, to read what the court had to say to this guy who submitted his case. Years later, I was in the Court of Appeals myself and talking to the clerk of the court, who by this time was at least one person or maybe two people removed from when I was there. And I was talking to him about, and somehow we stumbled on talking about that case, and he said, "You worked on that case?" I still cite that case to people who are submitting briefs in this court. And then it wasn't long after that that the Court of Appeals actually adopted a rule about length of briefs. So that was one case. Another case was a pornography case involving the film Deep Throat. I won't say I was disappointed. I'll say other law clerks in the court were disappointed that when the record on appeal came up to us, it did not include the film. But if you go to one of the libraries, I forget now the name of the case. It was some movie theater, basically, that was showing the case, and they were charged with whatever the charge was on pornography. You could never bring that case now. Criminally. It was a criminal case. But the DA's brief, if you want to read this, go and do a search of Deep Throat, and you'll find the case. And then once you know the case, you can go to any appellate division library and get the record on appeal. Not the record on appeal, but the DA's brief. The DA's brief was more pornographic than the movie was.
Prove the case.
It was something else. I don't remember the result in that case, frankly. Now that I mention it. Anyway, there were obviously more than anything, probably at least half the docket were criminal cases, and you were still undergoing this evolution of what had to be disclosed to criminal defendants, right to counsel, search and seizure, all of that stuff that maybe the Supreme Court had dealt with mostly in the 60s, and I think into the 70s. The Court of Appeals was dealing with. It was very interesting because Judge Wackler was on the court for the second of my 2 years. And he had a view that the identical words in the New York State Constitution that also appeared in the U.S. Constitution, maybe they just meant something different in New York State. And he didn't feel the least bit bound by what the Supreme Court meant when it read the same identical words.
Well, how do you think that 2-year stint with Judge Jason kind of impacted your skill sets, your abilities?
Well, there's no question. I did a lot of research, a lot of writing, and I got, I think I was always pretty good at that. I also had to, the way Jason did it, he would, as the cases came in, you get this big set of boxes of briefs and records that you had to go through during the 3 weeks you were in home chambers. Of course, at the same time, you were drafting opinions from the prior 2 weeks. The cases more or less got split up, odd numbers, even numbers, I don't remember, between the two law clerks. And you'd write up a bench memo for the judge, maybe 5 pages, and take a position. The court should affirm, the court should, and then you'd have an argument with the judge over that. And so there was, not that I had a stake in the outcome, but you'd write it up and you'd reach a conclusion, and you'd have to do some advocacy, if you will, if that's the right word. But it was so by the time that experience was over, and having been exposed to nothing but litigation for 2 years, that's what I wanted, more or less wanted to do.
So you come over to Phillips Lytle, now your 2-year term is up. Were you assigned to work with a partner? Was that how it was?
Not exactly. When I came back from the Court of Appeal, no, I'm trying to remember. Anyway, Paul Zydek was well, certainly he was the youngest litigation partner at the time. And I think he was kind of supervising most of my work, but the important thing was, over a course of a couple of years, I did work with every litigation partner in the firm, and learned, you'd learn from each one, and you'd learn different things from different ones, and sometimes you learn that this is a good way to do things, and maybe once in a while you'd learn that that's not the best way to do it, but it's so that was a very good training that I had.
Give me your best Alexander Sandy Cordes story.
In September 1984, I remember this because I had been out of the office for most of the summer because I had a minor ailment called a brain tumor that had been removed successfully. And but this was a case, at the time we were doing a lot of work for General Motors, a lot of their product liability cases for General Motors. The name of this case was Kaleri. And I had done most of the work. I won't say I did all the work on this case. And it was set for trial in September, and I had only come back to the office in late August, maybe. So Sandy was trying the case, but I was second chair with him. And I remember this Kaleri, he was a young, he was in his 20s, maybe early 20s, the plaintiff, who had been injured in this car accident. As a footnote, this was a period of time when General Motors seemed to be issuing recall letters on a daily basis on its cars, and those were just letters to plaintiffs' attorneys, please sue me for this. And so anytime there was an accident, a clever plaintiff's attorney would look at the recall history on this particular vehicle and say, right there, that's what happened. And so that's what this guy had done. And so I don't remember why, but the plaintiff's mother is testifying. And Sandy, I think it might have had to do with what the kid had been doing before the accident. I don't remember. But she's testifying, and Sandy's cross-examining her and kind of drilling down pretty good. And Sandy couldn't hear this. I'm sitting at the table, and the plaintiff himself is sitting at the other table. I could hear it. He said very quietly, "I'll break both your legs." I'll break both your legs. I didn't tell Sandy that story until after the case was over. We got a defense verdict. Actually, that's only one story from that case. We got a defense verdict. Phil Magner was the plaintiff's attorney, and we found out later he had been. No, that was a different case. All right, so I said the name of the case was Kaleri. Kaleri is the case that we tried in September of '84. The other case that I was describing, the kid whose mother was being cross-examined, was Malone, Frank Malone, M-I-L-O-N-E. That must have been, but I was second chair with Sandy on that. That must have been earlier. But it was another recall case. So I'll skip to Kaleri now. Phil Magner. We got a defense verdict in Malone. We got a defense verdict in Kaleri. Kaleri was a guy who had died in a car fire, And it was, they had to prove what caused the fire, right? Plaintiff did. And didn't, ultimately, in the view of the jury. Well, we had tried this case. We found out later that Phil Magner had been under instructions not to accept a verdict. Case didn't go in well for the plaintiff. So the instructions from the client would get us something, the widow. Well, Judge Mintz tried the case, and, there were summations and charge from the judge. And the very first thing the judge did after the jury went to start deliberations was he called the attorneys in, try to, work out a settlement. And at one point, I think he excused Magner right away, and he said, I just want to talk to the defendants here. And, we hadn't even started talking about the case. We were still talking about, the Sabres or the Bills or whatever. And there's a knock on the door. The jury had not even been out 45 minutes. There's a knock on the door, and it's the courtroom deputy saying there's a verdict. Phil Magner comes charging into chambers and says, Judge, I'm not taking a verdict. We accept the offer that was on the table. And Sandy says, what offer? You rejected any offer we made. There's no offer on the table. Jury comes in, reports no cause. We then, Mintz, to his credit, I think, he did the right thing, insisted that right then, right there, we make a record about how Magner had been, and he was trying to accept this offer. Mintz ruled against Magner, went to the appellate division. The appellate division agreed with us. We won there as well. Yeah, but that's another Sandy story.
Wow.
Sorry, I thought it was one story, one case, but it actually was two cases. Yeah.
Fantastic, that's fascinating. To those on the outside, Sandy had a reputation, but I was a non-litigator, just a couple years behind you, and but he had a reputation. Was it earned as a reputation? Is it a hard taskmaster, or was it something of respect, or somebody from afar?
Well, I worked with him for a number of years, and I think I started out being very concerned that he was a tough guy, and I mean, taskmaster, and he was. I mean, he had high expectations, and he expected people to fulfill them, and I guess I more or less did because, he kept me working with him. But there were a couple of times when maybe he hadn't gotten the best work product from me or whatever, and it was always very professional. It was, I never ran into, I never had a problem with it.
Was there a type of litigation, if you had to describe what Sandy normally did? Or is it defense work? Was it?
He did, he had been practicing law for a long time before I arrived here, so I can't really speak to what he did before I was here. When I was here, there was a lot of product liability, defense litigation, but there was other stuff. You could talk to Paul Stecker about the Batavia Turf Farm case, for example, which was not product liability. So maybe half his caseload at that point when I was working for him were product liability cases. I don't know. A lot of commercial litigation.
Now, did you there's never exclusivity, but did you kind of sort of major in working with Sandy, or were there other principal litigators you worked with?
I wouldn't say that. I mean, I worked with Ed Robinson on a number of cases. And by the way, I'll finish answering the question, but if you haven't been told the story about Desmond and Hitchcock, we need to talk about that. What did I say? Desmond, Robinson, and Hitchcock and Robinson and Desmond maybe too. So Robinson, Dave Floyd, I had a number of cases with. Now with Dave, Dave got to a point where at one point he was doing almost nothing but Love Canal. I never worked, I mean, I was, every now and then, I'd stick my nose in or get asked something about Love Canal, but I knew all about the litigation. I didn't actually work actively on the litigation, which I think is, someone told me there's sort of round 3 going on right now of the Love Canal litigation. One of the gifts that keeps on giving. So Hitchcock was really on his way out, and I might have worked on 1 or 2 things with Hitchcock, but not really much. Zydeck, I worked on a lot of stuff with Zydeck. Trying to think who, so Robinson, Desmond, Zydeck, Cordes, Floyd. Yeah.
Well, let's talk about, I'm just going to drop names and you can tell the story. Ryan Desmond. I remember parties at his place, just personally. We drive up there, I don't know, probably Marty or Sherry and I, forget, but we come up and he'd have parties at his house.
Yeah, yeah. Of course, Ryan had a tragic ending. And, and I, if I didn't say Desmond in that list of partners I'd worked with, he was one of them. One thing I remember very clearly, he had a case, he did a lot of cases, he did a lot of work at the time for the phone company. Mm-hmm. And he had, so when he died, we're just kind of splitting up his cases, and I ended up with a case in Warsaw, ready for trial, and it involved, it was a crazy incident where a telephone line, you remember there were telephones and telephone lines, and there was an attachment that would hook onto the side of a house, and then the wire would drop down and go into the house. And for whatever reason, this particular wire attachment had come loose. And this kid and his friends were out in the street playing touch football or something. And this wire is lying across the street. Some car comes along, tires snag the wire. The hook kind of spins up. It's still attached to the wire. Takes out the kid's eye. And, this is a young kid. And so the phone company gets sued for negligence for not attaching this fixture correctly, I guess. So actually, I'll just go to the end. I got a no cause in that case that no one ever thought would happen. But so I pick up this file, and for a very serious injury, the file is maybe that thick. I mean, there was nothing in it. He had taken a very, very short deposition of the plaintiff, and that was it. That was all I had.
Right.
That was all I had. So, we're coming up to trial, and, I'm at this point, I'm conducting my own investigation because no one else had, and figuring out who we can call and all this stuff. And I remember I had not done any work prior to this for the phone company. And I remember, it must have still been before the trial. I had sent the bill out to the client, and the client, I had 2 or 3 hours, I had been doing some investigation, and the client says to me, the in-house lawyer at the phone company, that was a Sunday. I said, I know it was a Sunday. I missed Sunday dinner to go out and do investigation for you. He didn't want to pay me because it was a Sunday, because he didn't think it was that I had done it. Obviously, they were pleased with the outcome. What was crazy about that case is the plaintiff's attorney was from Rochester, and You would recognize the name probably if I said it, but I won't. Very prominent plaintiff's attorney in Rochester. And at one point, the jury came back, it was on a Friday afternoon, the jury came back with a question to the judge: do we decide how much or just who's at fault? And so the judge calls the jury in and gives them a little clarifying instruction, saying essentially, look, first you determine liability, and then if you find liability, then you decide how much. Well, the plaintiff's attorney, and quite frankly, I sort of took it this way too, kind of read that as, well, the jury's already decided who's at fault, and now this is just how much. So the plaintiff's attorney and their client, they're out on the courthouse steps just yucking it up because they know they got a big verdict coming in. So about an hour later, okay, the jury's got a verdict and we all go in. No cause of action. And afterwards, the plaintiff just got out of there in a hurry. Afterwards, I stop and talk to a couple of the jurors. After the trial's over, you can talk to the jurors as much of this. They don't have to talk to you, but and I said, what was that question all about? Well, we were just kind of curious.
Wow.
Just kind of curious.
Sweat, caused a lot of sweat with all you guys. So give me your best, I just made a note here. Bill Reith, did you?
Oh, yeah, of course. I did a lot of work with Bill Reith. Yeah.
You talk about a file this big of Ryan Desmond. I just remember going to Bill Reith's office with seemingly an endless supply of files everywhere.
Yeah. Bill Reith, I didn't work on this case, but Bill Reith had the case we called the cow case. Did you ever hear about the cow case? Well, it was a bunch of dentists who, no offense to the medical profession. I've had marvelous experience over the years with doctors, dentists, for medical care. But my experience has always been that doctors and dentists are horrible when it comes to investing. They don't spend the time to really figure out what they're investing in. Somebody says it's a good idea. So there were a bunch of dentists who had invested in some herd of cattle or something. I don't know what it was or where it was. Stecker worked on the case. He could tell you more about it. But it was the cow case, and that case, when it was, might have even been an antitrust case. I don't remember, but that case just went on and on and on. But it was all about, this investment that this group of dentists had made in the cows.
And Bill was principally an antitrust guy.
Yeah.
Again, I'm from the outside looking in, but that was my sense.
Yeah, I would say.
Yeah. And you mentioned Robinson and Hitchcock, the connection.
Well,
there's a story there.
Yeah, and actually Hitchcock, both Hitchcock and Desmond love playing pranks on Robinson. Robinson could be very gullible. And one Hitchcock story that I remember is Robinson, who was a town judge in Amherst, had gotten himself appointed. I don't know how you do this, but he was an election judge, if that's the right term. So if there was some dispute at some polling place, he might get a phone call. And he had this little certificate or badge or something, and he always wanted to show these things off. And so in the afternoon of election day, there was no early voting at this time, middle of the afternoon of election day, Hitchcock gets on his phone and calls Robinson. Now, of course, there was no caller ID. You had no idea. Your phone rang, you picked it up, you had no idea who was calling, right? And Hitchcock did his best to imitate a little old nun from the East Side. They won't let me vote. And yeah, they told me I could call you and you would come over and take care of it. So Robinson goes charging out of his office, goes over to some polling place on the east side, and of course there's no there's no such thing going on. So Desmond, one thing I remember with Desmond and Robinson, I don't know if he had been in the Navy. I think his son was in the Navy, and not that it matters, but he had this naval clock in his office that he was very, very proud of. And he had it on his wall. It was a wall clock. And he was going around showing this off to everybody. He was very proud of it and was saying how accurate this clock was. And so one day Desmond would come in and move the hand 2 minutes forward. And the next day, 4 minutes backwards. It just kept doing this for a while, and convinced Robinson that we were, by this time we were fairly new in the tower then, the HSBC Center as it was then called. And Robinson was convinced that because of all the steel, or Desmond convinced Robinson that because of all the steel work, that was affecting the movement of the hands. And so Robinson kept moving it from one place on the wall to another, and that just seemed to go on forever. Then there was a second Robinson story, Desmond Robinson. They shared a secretary, Gloria Sartori, who was sort of legendary. She and my secretary never got along. There's some interesting stories there. So I don't know if it still exists, but we had a daily tickler that came around, and it had listed court appearances for the day, or if it was the last day to answer a complaint or last day to respond to a motion. That was all on the tickler. And of course at that time it was printed up and circulated to everybody in the office before 9 o'clock. And Desmond had intercepted whoever was doing it. Might have been Ann Bach, I don't remember. Well, she was ultimately doing it, but I don't know what he did to have the input. And he put on the tickler, last day to answer, and now I'm drawing a blank on the name. It was one of those old English cases that you read about in law school. That was 300 years old, and
Pearson versus Post.
It wasn't that one, but it's same idea. When we're done here, the name will come to me, of course, but it doesn't right now. And so Robinson wanders in, and Robinson was never one to get to the office early. He comes in 9:30, 10 o'clock, and Gloria's fit to be tied. Judge, it was always Judge. Judge, today's the last day to answer in whatever the name of the case was. She had no idea. And Robinson, of course, had no clue. He said, yeah, where is that file? I just had that file in my hands yesterday. So that went on all day until Desmond fessed up there was no such case.
That is too funny. Were there cases, Paul, where you found yourself, because you were a litigator, I mean, you are a litigator. Did you ever get asked to do anything else other than litigation? Did they ask you to hand you a real estate deal someday? Did they hand you
No, in fact, the only real estate deal I've ever been involved in was 52 years ago when I bought my house. and who did the closing? Marcia Brzezinski did the closing. Yeah. I never, no. There was, there was a little bit of work that I did that was almost regulatory, involving reimbursement rates for the Episcopal Church home. We did work for the Episcopal Church home, and I'll tell you what, that was, I never enjoyed that stuff, because that was just, who can understand all these state regulations and procedures? You really had to sort of specialize that in that.
I am reading Firm Beliefs, Dick Hirsch, the first 175 of Phillips Lytle, and one of the chapters is the relationship with DuPont dating to 1944, and it talks about how we got involved with DuPont and how they ultimately got into we, Phillips Lytle, got to be in a very select position at DuPont, which was a feather in our cap. Paul Zyda kind of was the point of contact, which in turn ended off to Lisa Smith. And they were talking about DuPont and how well we worked with them. And a good example, Smith said, is the work of Paul Jones, litigation partner. Jones is focused on defending claims related to a major DuPont product, ortho,
Toluidine.
thank you, an intermediate chemical widely produced commercially used in many products, da, 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 da. And that Jones had handled many of those cases and also frequently functions as a resource for other law firms in the DuPont legal network who are defending similar cases.
Yes.
Dicker.
Yeah, that's a true statement.
True statement. You recruited to be on that team, or did it come?
No, you know, I frankly, I had forgotten about that relationship, and I'm trying to put it into a time frame. DuPont, as a corporation, had decided that it no longer wanted to deal with whatever the number was, 50 or 100 law firms around the country, and they created a network that I think originally started out as just 12 or 15 law firms. And I think they simply called it the primary law firms, PLF, if I'm not mistaken. Zydak was certainly the point man on that, and it was, you know, it was a process to convince them, because, you know, you had 100 other law firms trying to get one of these slots, and Zydak got the job done, and we were one of those, again, whatever the number was, 12, 13, 15 law firms in that position. We had already been doing a lot of work for DuPont, but that certainly elevated our status with DuPont, and Lisa was right in what she said. We had these cases involving a legacy chemical, meaning a chemical that was no longer produced, but it was still out there, or people had worked with it 20 or 30 years, and now were claiming that they had bladder cancer as a result of exposures. It got to the point, because of various mergers, acquisitions, and retirements at DuPont, that there was no longer anybody at DuPont that knew anything about this chemical. And all of that information resided here. We had the documents, we knew what the information was, and when I retired 11 years ago, almost, I was very concerned that we had to be in a position to defend new cases if there were new cases. At the time, there were still some pending cases. The plaintiff's attorney who brought all of those cases, and a lot of them were in Buffalo, but a lot of them were elsewhere, and that's how we ended up working with these other law firms in other jurisdictions. The lawyer who was the plaintiff's attorney on all those cases, retired, and believe it or not, no more cases were ever filed. So, you know, who knows? Tomorrow, someone could come along and bring another case involving that chemical. We've got all the stuff here.
And you're the man to let them put in a wheelchair and walk, get you down here to?
Well, yes and no. I mean, Lisa, when I retired, Lisa and Kevin Hogan were working on those cases, and I think they've got a fair. I probably could be in the ground, and they could probably handle those cases. But, you know, I mean, that said, if there were new cases, I'd probably be getting a phone call from Phillips Lytle.
Are you still on council?
No,
No.
I'm a non-person. I'm sorry, I'm a capital R, capital P, retired partner,
Yeah, well, retired partner, so you could.
without a parking pass,
Without a parking lot, as you noticed today.
as I notice every time I come to a hockey game.
Ah, that's a critical part.
Yes, sir.
First of all, on the camera, I gotta thank you, you and I think it was Mike Powers also a Judge Jason?
Yeah, in fact, I may have a copy of it, a DVD, remember DVDs? He did quite, while Jason was still alive, he did quite a series of interviews with Jason. Very interesting. I mean, Jason was a very interesting guy. He had been, I'm sure, the first in his family not just to go to college, but to law school. The family name was Jasinski before it became Jason. And he was very well connected in the local Polish community, which then and now is a very vibrant community. But in World War II, I think it was after he had graduated from law school, I'm not 100% sure. It was toward the end of the war, and he was with a unit that liberated. I'd always thought it was a concentration camp, but I recently read that again, and I think it was a POW camp of French soldiers. And there's a famous photograph of him. It might even have been on the cover of Life, Look, one of those magazines at the time, of Jason with his revolver shooting off the lock on the fence that closed in this POW camp, and it worked out well for the POWs. But and then post-war, Jason, they kept Jason in Europe, and as part of the occupation force, he was a judge, I think in Heidelberg, but so he was a full-blown judge, but a local judge, handling local civil matters and local criminal matters, because Germany didn't have a government. We were the government. U.S. was the government in that post-war period. And so he had actually had hands-on experience, not in Nuremberg, but as a judge in that time frame.
And because of I started the Jackson Center in 2001, and I heard the story again. It might have been from you, might have been from Mike, either one of you, but both of you connected the dots that I had an interview and did what I'm doing with you, Paul, now, interviewed Judge Jason for about 2 hours, because at one moment in time, Judge Jason, in a curiosity moment, because he is the judge you mentioned, and doing, among other things, the denazification hearings, he just picked up the phone and said, hey, I'd like to meet Robert Jackson. And in fact, that happened. So he explained in some detail to me his day with Justice Jackson in Nuremberg, and what it was like, and the fact that they just basically sat and talked politics about Western New York the whole time.
Yeah.
What a thrill it was for Jason to meet Jackson in Nuremberg.
Sure.
But that wouldn't have happened but for the relationship that you two guys had that got me in the door. I interviewed him over.
Oh, okay, yeah, I got you. Yeah.
And so, so I thank you for that, because that's one of the many key interviews, and it's Paul Jones Nolan.
So, well, Jason was in Heidelberg. Jackson was in Nuremberg. Those cities are not very far apart.
He said he commandeered a Jeep.
Yeah, of course. Yeah, of course.
What are you going to do? There's so much.
Can I tell you a Gloria Sartori story?
Yeah, go ahead.
So I said that my longtime secretary before she retired was Elma Tillard. And we had, the secretaries had these cubicles with a partition, essentially. It didn't go all the way to the ceiling between them. And for quite a while, Alma, my secretary, was sitting just on the other side of this partition from Gloria Sartori. And my secretary smoked. And this was at a time when people smoked at their desks. A lot of the attorneys smoked at their desks. And certainly the secretaries, before there was any notion of having a smoking room or anything. And Gloria Sartori hated the cigarette smoke, understandably, but she hated it. And she hated the fact that Alma would be on the other side of the partition smoking. So what Alma would do every now and then was just pull out her lighter and click it a couple of times, and Gloria would start. We all got a kick out of it. Well, I said to you before we started this, just earlier today, that I was a very unlikely lawyer. I never started out with any notion in my mind until maybe my third year or so of college that was even on the horizon. And what had happened with me is, I was a physics major, and I liked physics. I liked, that all math and all that, and I was good at it. And then along the way, and this is sort of, third year of physics, physics turns into just a higher form of math, and it's all abstract. And I could do it. I mean, I did fine in those courses, but it didn't do anything for me. The part of physics where you could see it was, that's sort of what I. Later on, I realized, well, that probably meant I should have been an engineer. And my father was an electrical engineer. I should have known that, but no one whispered that into my ear. So I became a math teacher. That was horrible, and went to law school. My father, if I can toot his horn a little bit, he was an electrical engineer in the telephone industry when the telephone industry was not exactly in its infancy, but it was nowhere near developed as it is now. He spent his career designing telephone switching equipment, and if you've ever, you used to have to dial the number, and then the dial would come back. And he had, I think by the time he finished, 20 or 30 patents for telephone switching equipment.
So what's the Paul Jones legacy?
Legacy? 3 kids and 6 grandchildren. Yeah. Yeah.
And a lovely wife.
And a lovely wife. Or as all my Phillips Lytle partners used to call her, the long-suffering Mrs. Jones.
Yes. Again, thanks so much, Paul.
Thank you, sir.